All right, welcome back. I've got a fun doubleheader for you today. First, we're going to be looking at our friend Alec Baldwin. We covered his criminal charges a little while ago. And then after that, Baldwin's just going to be real quick. Our main feature, which I think is appropriate for today because it's the return of our old friends, the Brunson brothers. And it's appropriate, I think, to cover them today because as I'm recording this, there's still 40 minutes left in the day, and it's 420, April the 20th. And to put it bluntly, you'd have to be high to do the things the Brunsons are doing. So the other thing I considered doing today is, well, also something that I think it would be appropriate for the 20th, but I think is going to need more time. And I want to see how today's events shake down first and then just do one big episode to introduce it. But it's going to be the BitBoy crypto fiasco and discussing the overall lawsuit involved there. So I'm hoping to get that sometime this weekend. So, uh, with that being said, for those of you who are new here, I'm Joe. I'm an attorney in Utah, and let's jump into it. So, as promised, we start with Alec Baldwin. So, his charges were dropped today, which is a little bit surprising, but not super surprising. But that doesn't mean he's off the hook. So, I just randomly pulled up the CBS News article on it. It could have been any article on this. It didn't matter. Uh, so looking through the CBS article, says New Mexico prosecutors on Thursday evening confirmed they would be dropping criminal charges that were brought against actor Alec Baldwin for the fatal 2021 shooting on the set of his Western movie Rust. Baldwin was holding a gun while rehearsing a scene when it went off, killing cinematographer Helena Hutchins and wounding director Joel Souza. In a statement, special prosecutors Kari Morrissey and Jason Lewis announced that the involuntary manslaughter charges would be dismissed after new facts were revealed that demand further investigation and forensic analysis. Um, those new facts were discovered over the last few days while preparing for a preliminary hearing that was scheduled for May 3rd, according to the prosecutors. We therefore will be dismissing the involuntary manslaughter charges against Mr. Baldwin to conduct further investigation, the statement read. The prosecutors noted that charges may be refiled at a later date, pending the outcome of their investigation. Um, so basically, this is prosecutorial incompetence. You should know your evidence. Of course, it doesn't help that the Santa Fe district attorney hired a special prosecutor who was in the New Mexico state legislature, which meant she was both part of the legislative branch and acting for the executive branch as a prosecutor, which Baldwin's attorneys argued was a violation of the separation of powers, and therefore it was a problem. And they got her disqualified, brought in new prosecutors who had like a month and a half to get ready for the preliminary hearing, found evidence that they should have found already, but you know, the special prosecutor definitely should have found, and said, well, we don't have time. Baldwin could invoke his speedy trial rights, and then we're screwed. So instead, they're playing the games of, well, we're dismissing, but we could refile depending on what we find. So I'm going out on a limb. They're not going to refile. This is egg on their face. If they refile, that's even more egg on their face. It's just not going to look good for them. It doesn't look good for them, period, but it just, if you're eating a shit sandwich, don't add more shit. Um so if you recall, when I first covered this, I pretty much said I don't expect Baldwin to serve any prison time. I was under the impression, let's see if it does not mention the assistant director that has already pled guilty to a lesser charge. It I can't remember what the exact charge was, the exact wording. It was basically mishandling a firearm. And he pled guilty. His sentence was 6 months of unsupervised probation. So, and a fine. So that is pretty much nothing. Unsupervised probation. It's behave and nothing's going to happen. You don't even have to have a probation officer. It's literally behave. Um I pretty much figured there's no way they get a outright manslaughter conviction against Baldwin. If anything, they get basically the same plea agreement, mishandling the firearm, 6 months probation, maybe a year probation since the gun was in his hand. But as of now, I'm saying at worst, that's what happens in the future. But I don't think anything. Now, he does still face civil liability. He could still be sued. Well, I think he is being sued. Um, so it doesn't mean he's out of the woods, but I doubt he's going to face criminal jeopardy again. Um, that being said, the armorer, Hannah Gutierrez Reed, has not seen her charges dropped. So we don't know what this new evidence is, but it could be, bad news for Ms. Gutierrez Reed, because it could be that it shifts the blame more in her direction and off of Baldwin. Or, I mean, it could be bad evidence for Baldwin, but they just need more testing. So, that being said, I still think he doesn't face criminal consequences. So, that being said, let's jump into our main event. The Brunson brothers, specifically Raland Brunson. So, for those of you who don't remember, Raland Brunson is the galaxy brain that sued in Utah State Court to overturn the 2020 presidential election, remove Joe Biden from office, install Donald Trump as president, remove most of the House of Representatives and Senate, and pay Brunson $3 billion for his efforts. He thought a state court here in Utah could do that. which is insane. That case was kicked over to federal court, Utah District Federal Court. It was dismissed by the magistrate judge, Jared Bennett, who, like I said when I covered it, he was in the U.S. Attorney's office as an assistant U.S. attorney when I did my internship there. Fun fact. So there's a meme on the internet about bird law from, I think it originates from Always Sunny in Philadelphia. Well, Magistrate Judge Bennett has practiced bird law. He actually, I went to, it was supposed to be a trial, but the defendant didn't show up. It was for violations of the Migratory Bird Act. So he actually was practicing bird law, which is kind of amusing. But unfortunately, I didn't get to see much of it because the defendant didn't show up. But yeah, so he dismissed it. The 10th Circuit Court of Appeals affirmed the dismissal, and then the Supreme Court refused to take up the case because it's nonsense. So, what does Mr. Galaxy Brain, Raland Brunson, do? He sues 3 Supreme Court justices in Utah 2nd Judicial District Court. I don't think I have to say how ridiculous that is, but I'm going to. Because in what world, no disrespect at all to the Honorable Joseph Bean of the 2nd Judicial District Court of the state of Utah. I have a lot of criticisms of the Utah state government. Our judiciary is actually quite good, in my opinion. It's strange to me. Many states have partisan judicial elections, which I think is terrible. Utah has appointed judges who face retention elections, and it seems to work. So, no disrespect to Judge Bean, but in what world would he have the authority over the United States Supreme Court, over the highest court in the land? It's insane. It's absolutely insane. And like I said, I've covered this case, well, the previous case, quite extensively. I've made several videos on it, and I thought it was over. Like, I closed down the docket for it. And so I've got to give thanks actually to Reddit. Once it loads, this was posted to my being is the sovereign citizen Reddit thread. Let Oh, that's the wrong print. Nonsense. But this was posted by New Tracks for Nerves. So thank you to New Tracks for Nerves. And I thought it was done. I really did. I mean, he said after the Supreme Court refused to take the case, well, I've still got some, tricks up my sleeves, and I scoffed. Apparently, this was that trick up his sleeve. And I'll show you after we go over the case. Like I mentioned covering this nonsense that I wasn't positive if the Brunsons are sovereign citizens or not. There's a lot of sovereign citizen adjacent language. The problem is here in Utah, there's a large chunk of the population that is not sovereign citizen, but they're a gust of wind from being blown into sovereign citizen territory. So I thought he might be one of those, but I think I might have been wrong. I think he might actually be full blown sovereign citizen, true believer. But that said, let's jump into the complaint. Raland J. Brunson, plaintiff, versus named persons in their capacities as honorable justices of the Supreme Court of the United States. Sonia Sotomayor, Elena Kagan, Ketanji Brown Jackson, John and Jane Doe's 1 through 100 defendants. 100 John and Jane Doe's. He's trying to outdo delete laws. He only has 50 John Does. But you'll notice, though, this is 3 Supreme Court justices named. Justices Sotomayor and Kagan were appointed by President Obama. Justice Brown Jackson by President Biden. So it's the 3 liberal justices named, none of the conservative justices. But that doesn't make sense, as we'll discuss shortly. So, comes now plaintiff Raland J. Brunson, in pro se, based upon facts, information, and beliefs, alleges against defendants as follows. Parties and jurisdiction. Plaintiff is an individual residing in Weber County, state of Utah. Defendants all have an office or workplace in Washington, D.C. Plaintiff's right to bring this action includes, but not limited to, Amendment 1 of the United States Constitution, which states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble, and, underlined, to petition the government for a redress of grievances. That's his jurisdiction. Even though if you had if this were a legitimate cause of action, it still wouldn't be the correct venue. This state court does not have jurisdiction over the Supreme Court. And he says, this court has jurisdiction pursuant to Utah Code Annotated 78B 3-307. I'm not going to pull that up. I covered it in the first video I did on these guys. He's wrong. Supportive backdrop common to all allegations. The Constitution. We, the people, created our government. Therefore, we are the creators of our government. And if we are the creators of our government, then in simple terms, we are the rulers of our government. We are the masters, and government is our servant. Or we are the employers, and government is our employee. Government works for we, the people, and is subject to we, the people. And whenever government acts in ways that is contrary to our God-given rights, as referred in the Declaration of Independence, then we have the right to abolish it and to institute new government that will be subject to we as their employers and rulers. See the second clause of the Declaration of Independence. Fun fact, the Declaration of Independence is not a governing document. The Constitution is. We, the people, have commissioned government to secure our rights. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. See the second clause of the Declaration of Independence. Therefore, we have instructed government and memorialized in public record that our rights are not given to us by government. Therefore, in commissioning a government to secure these rights, we, the people, created the Constitution of the United States with the first 10 amendments, which was ratified in 1791. This is the official and only Constitution. The first 10 amendments were defined by Congress as further declaratory and restrictive clauses. I mean, is he trying to claim that the main body of the Constitution and the first 10 amendments, the Bill of Rights, are the only Constitution? So does that mean the 13th Amendment doesn't exist? So, hey, everyone, go get your slaves. Does that mean the 14th Amendment doesn't exist? So, hey, the states aren't bound by the First Amendment or the Fifth Amendment or the Fourth Amendment or the Seventh Amendment. So they can hold you for trial and search you without warrants and restrict your free speech and ban your religion and all this stuff. It's just the federal government that can't because the 14th Amendment doesn't exist. All you women out there, I hope you enjoyed voting because you can't anymore. Sorry. I mean, that's how I'm reading this. I could be wrong, but these clauses are set in place to restrict the Constitution from ever being an instrument that government could use to infringe upon our rights of we the people. On this premise, these rights shall always restrict our government. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 9. Brunson received his rights by our divine creator, and the Constitution is set in place to protect these rights. Therefore, we, the people, are the master, ruler, or employer of our government. How often do we hear sovereign citizens? Are you a public servant? You're my servant. It- It's they are public servants, not your servants. They are not beholden to you specifically. They're beholden to, as he keeps putting in quotation marks here, we the people. That means all Americans, not just this lunatic. He doesn't get to decide for all Americans who the president is. There was an election for that. His guy lost. The Congress is not beholden to his whims. The Supreme Court is not beholden to his whims. Sovereign citizens don't understand. There's 340 some million people here. They've got to represent all of us. It's that simple. The second clause of the Declaration of Independence states, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. He already had that a few paragraphs above, but our unalienable rights are given to us from God, and therefore no government has the legal power to make laws that deny or disparage them without being guilty of committing crimes against humanity. Crimes against humanity. Joe Biden being in office is a crime against humanity. I know a lot of you don't like Joe Biden. That's fine. But, you know, my grandmother grew up in Nazi Germany. They knew a thing or two about crimes against humanity. Having the wrong guy in office is not it. The Utah State Supreme Court supports the fact that our rights do not come from government, as found in the case of American Bush versus City of South Salt Lake. I love that this ultra religious plaintiff uses a case in support of a strip club for his argument. It the irony isn't lost on me. American Bush, I don't know that it still exists, but it at least was a strip club here in the Salt Lake area. I think in South Salt Lake. Well, yeah, city of South Salt Lake, so that makes sense. And American Bush versus South Salt Lake states, in considering state constitutions, we must not commit the mistake of supposing that, because individual rights are guarded and protected by them, they must also be considered as owing their origin to them. These instruments measure the powers of the rulers, but they do not measure the rights of the governed. A state constitution is not the beginning of a community, nor the origin of private rights. It is not the fountain of law, nor the incipient state of government. It is not the cause, but consequence of personal and political freedom. It grants no rights to the people, in bold, but is the creature of their power, the instrument of their convenience, designed for their protection in the enjoyment of the rights and powers which they possessed before the Constitution was made. It is but the framework of the political government. It presupposes an organized society, law, order, property, personal freedom, a love of political liberty, and enough of cultivated intelligence to know how to guard it against the encroachments of tyranny. Now, you may notice that speaking about the state constitution, the state of Utah and its constitution has absolutely no effect on the United Supreme Court. It just doesn't have any impact on the United States federal government. Sorry. Amendment 9 of the Constitution of the United States, known as the Interpretation Clause, clarifies the fact that no government has the right to misconstrue with our said rights, which states, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, Congress has no power to enact laws that would violate our God-given rights. So, by that logic, Congress has no rights to overturn an election that is laid out in the Constitution and various other federal laws. And so the Ninth Amendment would say, hey, Congress can't take away my right to vote or nullify my vote, or, the almost 80 million people who voted for Biden, nor to nullify the 74 million votes for Trump. Or, I mean, that's the way I read the Ninth Amendment. Powers put into place that fail to protect our said rights entitle mankind to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. First clause of the Declaration of Independence. So is he trying to secede from the Union? The exclusive powers extended to the legislative branch of Congress for the making of laws are subject to Amendment 9 of the United States Constitution, and as such, this Constitution and the laws of the United States, which shall be made pursuance thereof, shall be the supreme law of the land. See Article 6 or of the U.S. Constitution. Yeah. What? Why are you quoting the Sixth Amendment in support of the Ninth Amendment? That doesn't make sense. And now I think we're getting into the Mormon bits here. The U.S. Constitution was written with honor, respect, and recognition of our Lord Jesus Christ, as memorialized in Article 7, Clause 3, which states, in the year of our Lord. The prophet Isaiah, chapter 30, verse 9 of the King James Bible states that this is a rebellious people, lying children, children that will not hear the law of the Lord. The law of the Lord, spoken of by Isaiah, is the U.S. Constitution, as claimed by George Albert Smith, a former president of the Church of Jesus Christ of Latter-day Saints, the Mormon Church. Remember how he said that the Supreme Court violated his First Amendment by denying his right to petition for the redress of his grievances. Um, yeah, the Establishment Clause would say, yeah, the law, the Constitution, and the laws of the land are not the law of the Lord. I mean, you. I'm not saying Brunson can't believe that. I'm not saying you can't believe that. I'm saying kind of violates the Establishment Clause if the government says it. George Albert Smith, on September 23rd, 1945, while giving a dedicatory prayer of the Idaho Temple, stated, "For this purpose have I established the Constitution of this land." Doctrine and Covenants, chapter 101, verse 80. The Doctrine and Covenants being one of the Mormon scriptures. And as I've mentioned before, I grew up attending the Mormon church, have not since I was 18, so I'm not fully up on all the lore. But George Albert Smith, his father was John Henry Smith, who hang on, whose father was a different George Albert Smith, whose dad was John Smith, who was the younger brother of Joseph Smith Sr., the uncle of the founder of Mormonism, Joseph Smith Jr. So basically, this George Albert Smith being quoted, his grandfather was Joseph Smith's cousin. So, yeah. Not that that matters, it just adds context. So, for this purpose have I established the Constitution of this land, from the Doctrine and Covenants, to fulfill the ancient prophecy of Isaiah that out of Zion shall go forth the law and the word of the Lord from Jerusalem. Yeah. Mormon, and that's from Isaiah chapter 2, verse 3. Mormons, you know, they built Salt Lake to be a new Jerusalem, and there's a reason why Zion National Park here in Utah is named Zion National Park. Yeah. The said DNC is the Doctrine and Covenants of the Church of Jesus Christ of Latter-day Saints. The oath of office. Defendants swore an allegiance to the Constitution, known as the oath of office. Let it simply be asked, where is the security for property, for reputation for life, if the sense of moral and religious obligation desert the oaths which are the instrument of investigation in courts of justice? George Washington on the Sanctity of Oaths. Chapter 5, United States Code, Section 3331 states, an individual, except the president, elected or appointed to an office of honor or profit in the civil service or uniformed services, shall take the following oath. I, my name, do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter, so help me God. This section does not affect other oaths required by law. So, fun fact, I've taken that oath twice. Once to start my internship at the U.S. Attorney's Office, and once to start my internship at the Securities and Exchange Commission. The U.S. Constitution, Article 6, Clause 3 states, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Chapter 5 U.S. Code, Section 7311 states, an individual may not accept or hold a position in the government of the United States or the government of the District of Columbia if he, 1, advocates the overthrow of our constitutional form of government. Sounds to me like maybe Mr. Brunson should be barred under that. Not that he's electable even here in Utah. Number 2 is a member of an organization that he knows advocates for the overthrow of our constitutional form of government. 3, participates in a strike or asserts the right to strike against the government of the United States or the government of the District of Columbia. Or 4, is a member of an organization of employees of the government of the United States or of individuals employed by the government of the District of Columbia that he knows asserts the right to strike against the government of the United States or the government of the District of Columbia. Chapter 18, U.S. Code, Section 1918 states, whoever violates the provision of Section 7311 of Title V, that an individual may not accept or hold a position in the government of the United States or the government of the District of Columbia if he, 1, advocates the overthrow of our constitutional form of government, 2, is a member of an organization that he knows advocates the overthrow of our constitutional form of government, or 3, participates in a strike or asserts the right to strike against the government of the United States or the government of the District of Columbia, or 5, is a member of an organization that employees of the is a member of an organization of employees of the government of the United States or of individuals employed by the government of the District of Columbia that he knows asserts the right to strike against the government of the United States or the government of the District of Columbia, shall be fined under this title or imprisoned not more than 1 day, 1 year and a day, or both. The definition of advocate is further specified in Executive Order 10-450, which, for the purposes of enforcement, supplements 5 U.S.C. 7311. One provision of Executive Order 10-450 specifies it is a violation of 5 U.S.C. 7311 for any person taking the oath of office to advocate the alteration of the form of the government of the United States by unconstitutional means. Our form of government is defined by the Constitution of the United States. It can only be altered by constitutional amendment while adhering strictly to the controlling clause of Amendment 9. Fun fact, if the Constitution is amended and that new amendment isn't in conformity with the Ninth Amendment, it's still a valid amendment. It means, hey, because the Ninth Amendment says, hey, the powers not reserved to the federal government are for the people. But if the Constitution is amended and it says, hey, the federal government specifically has this power, then the federal government now has that power because it's in the Constitution. The Ninth Amendment doesn't apply to that power. It means all the other powers not enumerated are for the people. Thus, according to Executive Order 10450, and therefore 5 USC 7311, any act taken by government officials who have taken the oath of office prescribed by 5 USC 3331, which alters the form of government but other than by amendment, is a criminal violation of 5 USC 7311. They didn't. We still have a president. We still have a Congress. We still have a judiciary. We're still a constitutional republic, democratic republic. How has the form of government changed? Who sits in office has no bearing on the form of the government. I mean that the contract, being that we, the people, created the Constitution to protect our said rights, the oath of office that the defendants have taken is a contract. It binds them to restrictions from ever protecting laws that would violate Brunson's rights. The defendants swore to uphold, protect, and defend the Constitution with penalties for certain violations. Whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid or comfort within the United States or elsewhere, is guilty of treason and shall suffer death or shall be imprisoned not less than 5 years and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States. See 18 U.S. Code, Section 2381. Defendants are sworn to be the defenders of Brunson's rights by way of the Constitution. This is their duty. This is their contract, which they freely agreed and swore to do. Facts common to all allegations. On January 6th, 2023, Brunson's seriously, this was on January 6th, 2023. It was on January 6th, 2023. The 1-year anniversary of the complained about failure to investigate on January 6th, 2022. But on January 6th, 2023, Brunson's petition for writ of cert, the petition, was scheduled for conference. Docket number 22-380 of the Supreme Court of the United States, SCOTUS. This petition perfected constructive knowledge, footnote 1, to defendants of the following. Let's look at footnote 1. Constructive notice in law creates an irrebuttable presumption of actual notice, Mooney v. Harlan. So, constructive knowledge to the Supreme Court of the following. The petition alleged as an uncontestable fact that a serious national security breach exists. And in order to correct or remedy this breach, it would require the removal of a sitting president and vice president of the United States, along with many members of Congress. The petition also alleged as an uncontestable fact that the named respondents in the petition had violated their oath of office by giving aid and comfort to an enemy raging war against the Constitution and the United States, according to 18 U.S. Code 2381. This is an act of treason. The petition alleges that this war is current and ongoing. Pursuant to the petition, the respondents became enemies raging war against the Constitution and the United States. The petition stated that during the 117th session of Congress, 100 members of Congress claimed to have provided facts and evidence that the 2020 presidential election was breached, and therefore moved Congress to investigate these claims. The respondents on that day voted not to investigate these claims, despite the fact that a breach in the electoral process is an act of war. The purpose of war is to put into power its victor, and a breach in the electoral process does the same thing, to put into power its victor. So, on January 6th, 2021, oops, I said 2022, I meant. So it was the second anniversary of January 6th, 2021. Pursuant to 18 U.S. Code 2381, the respondents committed high treason by becoming enemies waging war. This time it's waging war instead of raging war, as was said the first couple times, against the Constitution and the United States by voting to thwart the investigation of claims that the said election was breached. The petition also stated that the doctrine of equitable maxim created by SCOTUS violates the object principle of justice. We discussed both of those nonsenses in the last video on this. And that had SCOTUS granted docket number 18-1147, this would have given SCOTUS the opportunity to rectify these serious conflicting doctrines affecting every court in the United States. It is emphatically the province and duty of the judicial department to say what the law is. Quoting Marbury versus Madison. Despite defendants being recipients of the said constructive notice, on January 9th, the docket of SCOTUS posted that the petition was denied. Defendants did not provide any reason for this denial. Fun fact, they don't. They never say this is why it was denied. And there are 9 justices. Each justice has either 3 or 4 clerks for each term. that they'd have to create a whole bureaucracy to explain on every case why it was denied. And it, here's the thing. So I didn't pull it up on screen, just on my handy dandy phone. Um, so the Supreme Court receives more than 7,000 petitions every year to hear their case. They take up, on average, between 100 and 150 cases out of 7,000. Could you imagine how much more work it would be if they had to provide reasons why they denied cert on all 7,000 of those cases? Generally, these cases have already been heard by one of the Circuit Court of Appeals, such as this one was heard by the 10th Circuit Court of Appeals. Or they have been heard by the state Supreme Court, and then that was petitioned to the Supreme Court. So you already have your reason why cert was denied. It's because in this case, the Supreme Court agrees with the 10th Circuit. That's your reason. Easy. Pursuant to defendant's duty under their contract and under Marbury versus Madison and under the object principle of justice, defendants had a duty to address the petition and to disregard the Judicial Act of 1925, which unconstitutionally gave them power of discretion in deciding what cases they wished to address. The Supreme Court is a court of limited jurisdiction. They I mean, if they don't have the power to decide which cases they address, either they hear all 7,000 cases in a year. That means 20 a day every day throughout the year. At an hour a day, that's 20 hours. So when are they going to write their opinions? When are they going to discuss it in chambers amongst themselves? When are they going to sleep? Well, in that case, you split the Supreme Court into multiple sections and you just have them hear a fraction of the cases. But then who decides if they disagree? Well, you send it up to a selection of the Supreme Court justices. So you mean you have circuit courts and then the Supreme Court? This is utter stupidity from Brunson. The Supreme Court would not function if they had to hear 7,000 cases a year. And that 7,000 cases a year, some fraction is prisoners who have nothing better to do. And so they say, I'm going to petition myself without the help of a lawyer to the Supreme Court because what do I have to lose? There's some of those in that 7,000. But do you know what's not in that 7,000? It's lawyers who say, I think the Court of Appeals got it wrong, but there's no chance the Supreme Court is going to take this case. This isn't the right one for them to take. So they don't even bother petitioning for cert. If the Supreme Court had to hear every case, then every appeal is going to the Supreme Court. And there's going to be tens of thousands a year. And it breaks even further. So proceeding. On January 9th, 2023, the defendants denied the petition without reason. And you'll notice it's the defendants denied the petition without reason. Now, I said I'd get to this. Now's as good a time as any to get to this. It wasn't just defendants who denied the petition without reason. For a case to be granted cert, it takes 4 of the 9 justices to vote to grant it cert. Which means, at a minimum, to have a case heard, it requires a 4 versus 5 vote. But because this case is not being heard, at best for Brunson, it received a 3 versus 6 vote, meaning at least 3 more justices who are not named as defendants voted not to hear the case. For all we know, let's assume that 3 justices did vote to hear the case. For all we know, it could be the 3 named defendants voted to hear the case, and the 6 justices who are not defendants voted against hearing the case. But Joe, you may say, why would these justices have voted to hear the case? Sometimes the justices who vote to take up a case vote that way, not because they're in support of the legal argument of the appellant. It's because they think it's ridiculous and they want to put it on, they want the opposite to be binding law. So let's say there's a Fourth Amendment case that comes up to the court at some point. The lower court said the Fourth Amendment does not prevent the search of everyone's nostrils for signs of cocaine use and blah, blah, blah. Ridiculous case. And for some reason, the Court of Appeals said, yeah, that sounds reasonable. So, search the nostrils. Well, the Supreme Court justices might, that they're going to vote to take up that case and grant it cert and then say, This is ridiculous. You can't search nostrils without probable cause. So, do I think these three justices did vote to hear this case? No. It's so ridiculous. And Magistrate Jared Bennett got it right. The 10th Circuit got it right. The Supreme Court doesn't need to say, well, yeah, they got it right. They just say denied. It stands. But continuing. And then on January 23rd, 2023, Brunson's filed a petition for rehearing. Once again, this rehearing perfected constructive notice to defendants of what has already been given to defendants. The rehearing also perfected constructive notice to defendants of 1. How binding the oath of office is. 2. How investigation has monumental importance in identifying an enemy. 3. How allegations of war should be investigated. 4. How petitioning the government for redress of grievances can be done through a lawsuit. I think the Supreme Court understands that that's what it is. 5. How defendants should adjudicate this case. 6. How fraud vitiated Congress's power to count the votes under Amendment 12 until the investigation resolved any claims of a breach in the electoral process. And 7. How the doctrine of equitable maxim is unconstitutional. The rehearing was set for a conference date February 17th, 2023. On February 21st, 2023, the rehearing was denied, constituting the same breach as stated above by the defendants. First cause of action, breach of contract as to all the defendants. Plaintiff hereby incorporates blah, blah, blah. On October 20th, 2022, defendants entered into an agreement known as the petition. Under the terms of this petition, Brunson paid defendants $300 in addition to their paid salary. And then Brunson received from defendants a docket number 22-380 on or about October 20th, 2022. Per the above statements, defendants had a duty, a contract, to hear Brunson's petition. The defendants breached their sworn duty, their contract with Brunson as described above, when they denied the petition. Brunson then again approached the defendants and paid them another $200 on January 23rd, 2023, under known as a rehearing, in order for them to hear his petition. And then, on February 21st, 2020, defendant denied the rehearing without giving any reason whatsoever. These denials damaged Brunson of the dollar amount he's seeking against the respondents in the full total amount of $2,905,000,000 in U.S. legal tender, tax-free. Funny story. Not everything is a contract. Sovereign citizens like to pretend everything's a contract. Not everything's a contract. Contract law does not bind the Supreme Court to take every case. But Joe, they paid a filing fee. Well, number one, that filing fee does not go to the Supreme Court justices. It pays a minuscule portion of the operation of the Supreme Court. But if Brunson had read, I'm sure it's not even fine print, and I'm not going to look for it because it's ridiculous, but I guarantee that it says front and center that there's no guarantee the Supreme Court takes your case. But second cause of action, intentional infliction of emotional distress as to all the defendants. Now, I've said before, RICO is the lupus of the legal world. Intentional infliction of emotional distress is very close to RICO. And it's never RICO. It's also almost never intentional infliction of emotional distress. It's a very high bar for that tort. And it only applies to very specific circumstances. And those circumstances are rarely met. But each of the defendants took their oath of office without any mental reservations, knowing full well what it meant. As stated above, the oath of office is also a promise to Brunson. The defendants purposely and maliciously violated their oath of office when they denied the petition and rehearing. This denial is an assault against Brunson's well being and general sense of safety, and it has served upon Brunson emotional damage, causing him fear from the highest court in the land that was set up to be the keeper of Brunson's rights, but instead offers protection against such violators. This damage causes fear that defendants are now on a course to violate Brunson's right to freely travel, to make a living, to have privacy, to own property, and essentially destroying his liberties. That right to freely travel, I'm thinking sovereign citizen. Brunson's daily emotional distress and suffering finds moments of relief when Brunson envisions that the defendants be removed from office without delay for violating their oath. Third cause of action, fraud as to all the defendants. In Washington, D.C., on January 6th, 2023, and on February 23rd, 2023, defendants made public Brunson's petition and rehearing, to which they agreed that they would protect Brunson's right to be heard, and that they would vindicate Brunson for the damages caused by the respondents, who have engaged in fraud and war against Brunson and the Constitution, as stated in the petition and rehearing. As stated above, the defendants knew that Brunson relied upon them to stop the war when he paid his filing fee money and when the defendants accepted their salary. On January 21st, 2023, defendants denied the petition, and then on February 23rd, defendants denied the rehearing. These two denials completed the fraudulent acts of defendants, and they kept the filing fee money along with their paid salaries. Notice it's a filing fee, not a hearing fee. According to 18 U.S. Code 2381, the defendants committed acts of treason and committed fraud against Brunson when they denied the petition and rehearing for the reasons stated above. So, fraud against Brunson is treason, apparently. Fourth cause of action, civil conspiracy as to all the defendants. Each of the causes of action stated herein tie into this cause of action. Defendants all worked in concert, committing civil conspiracy in denying the petition and rehearing, which provides the dates, where, and who was all involved. The defendants had constructive knowledge, knowing full well that their denial of the petition and rehearing were acts of, but not limited to, fraud. Wherefore, plaintiff prays for relief against the defendants as follows, with any and all money damages to be tax-free. Because, once again, a state court judge has the power to declare what is and is not to be taxed by the federal government. Relief under the first cause of action. Defendants are to be removed from office with an order that they never be allowed to serve in any government office found anywhere in the United States of America, nor serve in the legal profession for the rest of their lives. A state court judge, this doesn't need to be said, does not have the power over the Supreme Court to decide the composition of the Supreme Court. That is ridiculous. Now, funny enough, a state Supreme Court has the power over law licenses, but a state district court does not. Defendants shall be forbidden to collect any further payments or retirements or income derived from the U.S. government for their services rendered to the U.S. government. Judgment against defendants shall incorporate the fact that each of the defendants failed to protect the U.S. Constitution. Judgment against the defendants shall incorporate the fact that each of the defendants gave aid and comfort to enemies of the U.S. Constitution. Judgment against the defendants shall incorporate a recommendation that the defendants should be investigated for treason, according to 18 U.S. Code, Section 2381. Defendants shall each pay $938,333,333 in U.S. legal tender, tax-free. This is 1/3 of $2,905,000,000. Relief under the second cause of action. Defendants are to be removed from office with an order that they are never to be allowed to serve in any government office found anywhere in the United States of America, nor serve in the legal profession for the rest of their lives. Defendants shall be forbidden to collect any further payments or retirements or income derived from the U.S. government for their services rendered to the U.S. government. And once again, the Supremacy Clause. It goes without saying, but I'm going to say it anyways. In what world does the state of Utah have the authority to tell the federal government who it is and is not allowed to pay? Judgment against the defendants shall incorporate the fact that each of the defendants failed to protect the U.S. Constitution. Judgment against the defendants shall incorporate the fact that each of the defendants gave aid and comfort to enemies of the U.S. Constitution. Judgment against the defendants shall incorporate a recommendation that the defendants should be investigated for treason. Defendants shall each pay $10 million payable in United States legal tender money. But not tax-free? I'm shocked. Relief under the third cause of action. Defendants are to be removed from office with an order that they are never to be allowed to serve in any government office found anywhere in the United States of America, nor serve in the legal profession for the rest of their lives. Defendants shall be forbidden to collect any further payments or retirements or income derived from the U.S. government for their services rendered to the U.S. government. Judgment against defendants shall incorporate the fact that each of the defendants failed to protect the U.S. Constitution. Judgment against the defendants shall incorporate the fact that each of the defendants gave aid and comfort to enemies of the U.S. Constitution. Judgment against defendants shall incorporate a recommendation that the defendants should be investigated for treason according to 18 U.S.C. 2381. Defendants shall each pay $10 million payable in United States legal tender money. Relief under the fourth cause of action. Defendants are to be removed from office with an order that they are never to be allowed to serve in any government office found anywhere in the U.S., nor serve in the legal profession for the rest of their lives. Defendants shall be forbidden to collect any further payments. So same, $10 million each. Total amount of money damages, tax-free, $3,108,000,000 of U.S. legal currency, and for any such other relief that the court may deem proper. Dated this 7th day of March, 2023, Raland J. Brunson, plaintiff. Yikes. I'm actually surprised that he didn't ask for the Utah District Court judge, Judge Bean, to force the Supreme Court to hear his case, or to force the Supreme Court to rule in his favor on the previous case. Yes, those are both absolutely asinine, but no less so than the rest of this case or the previous cases. It's absolutely nonsense. So I promised at the beginning that I would discuss why I've come to the conclusion that he is a sovereign citizen, not just sovereign citizen adjacent, which I thought he might be, but had, I was on the fence. He was either a sovereign citizen or adjacent, but this has tipped me into, yeah, he is a sovereign citizen. So once again, from r/am I being detained, the user New Tracks for Nerves. Very, thank you to him or her. So they posted with the original post about the suit that this is just fully quoting their Reddit post. Raland Brunson is good buddies with Ken and Barbie Cromar, who have an ongoing feud with the IRS and the government in general over seizure of their home and their forcible eviction for unpaid income taxes. Raland gave them an exclusive scoop about his filing. He has now given them uh, an exclusive scoop about the brilliant legal thinking behind the filing. Ken Cromar is impressed. In talking at length in follow up today with Raland, this is quoting Ken Cromar, a number of points about his unique case were discussed. His law strategy seems quite well thought out, reasonable, rational, and by this editor's estimation, brilliant. Raland Brunson, along with his three brothers, Loy, Darren, and Gaynor, have understandably and appropriately been seen as patriot heroes fighting for all of we the people. And that they are. These men are the kind of men who should be sitting as senators, congressmen, etc., not the oath-breaking wannabes that fill the nation's capital and so many state capitol buildings in the 50 states. So, running back to the legal filing, the complaint, if you notice the URL here, it's cedarhillscitizens.org. And that is the Cromar's blog. Now, Cedar Hills, for those of you who don't know Utah geography, and why wouldn't you know Utah geography? Cedar Hills is a fairly affluent community in Utah County. So think Provo. It is to the east of Highland and to the south of Alpine, right at the mouth of Provo Canyon and settled up against Mount Timpanogos. So, for those of you not from Utah who have come through and gone to Timpanogos Caves, which is a neat tourist attraction here in Utah, it's on your drive, basically right as you're entering the canyon. Cedar Hills will be on your right. And apparently, Ken Cromar was a city councilman for Cedar Hills in the late 90s. I seem to remember him being in the news on and off some time ago. But so this is surprise. Raland Brunson has served 3 SCOTUS justices. Read it here. And then let's see. Surprise part 2. More details on Raland Brunson's service to Supreme Court Justices Sotomayor, Kagan, and Jackson. Game on. And it says, yesterday, this editor, Ken Cromar, former Cedar Hills councilman, 1994 to 2000, Raland Brunson declared that I was the first to whom he divulged that his stealth court case filed against 3 Supreme Court justices, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson. In talking at length in follow-up today with Raland, a number of points about his unique case were discussed. Point 1. Sometimes it's not what is said, but rather what is not said that is most important. Therefore, what the 3 justice defendants did not say or do was they did not stay or cause the case to be vacated or deleted. That's because they're defendants. The case is not before them. Funny how that works. Judge Bean is the one who will dismiss the case. The justice could have exercised a prerogative outside of their own rules, which requires a decision on a case before ruling, and could have simply nuked it. They did not. Point 2. Any justice of the Supreme Court of the United States has the authority to order a stay without any other justice getting involved. No, they don't. They can order a stay, but not on state court cases, which this is. But basically, each of the justices is allocated a district, basically, where they are the justice in charge of a circuit or 2, and they can issue a stay, a temporary stay, on a ruling in anticipation of taking up the case. But they don't do that upon a complaint being filed. This is ridiculous. Point 3. Raland believes that due to the sheer quantity of cases dealt with by the Supreme Court in court's in-house counsel, that it is very possible that the 3 justices very likely have no idea that they've been served by Brunson. Instead, it is likely that their attorneys are just following their normal day-to-day procedures, protecting the justices from any personal liabilities. Yeah. Same as when he sued Congress. Congress had no idea. A U.S. attorney filed a motion to dismiss. That's what's going to happen here. The justices aren't going to defend themselves. It's going to be a U.S. attorney, and it's going to be an easy dismissal for them. Point 4. Raland points out that somebody is taking this seriously, as the justices have all 3 lawyered up and have listed Trina Higgins and Amanda Berndt. They haven't lawyered up. These are the Trina Higgins, the U.S. attorney, and Amanda Berndt, assistant U.S. attorney. They haven't lawyered up. These are government employees who are going to file a motion to dismiss. Exact same procedure as his previous lawsuit against Biden and Congress. Point 5. We mused together at the obvious and absurdly false legal doctrine that judges like to trumpet to justify anything and everything they do, called absolute judicial immunity, or sometimes calling sovereign immunity. Basically, the doctrine claims that you cannot hold a judge personally accountable or even judicially accountable for any bad actions or constitutional violations because they are above it all and immune. In other words, they've crowned themselves gods, no infallible gods, incapable of error, just because they've said so. Yes, judges do enjoy absolute judicial immunity. But why do I think these people, the Cromars, are sovereign citizens? Well, besides, their IRS dispute and government disputes mentioned in the Reddit post. Just looking at recent blog posts, we have this one. The Farmington Freedom Parade in memory of young patriot Chase Allen at noon on April 15th. Another case we've covered recently. And this is the flyer. Farmington Freedom Parade. Exercise your God-given right to travel in memory of Chase Allen. Hashtag Justice for Chase. Come to the Farmington, Utah Post Office, 145 East State Street, Saturday, April 15th at noon. We will parade our private conveyances, cars, trucks, jeeps, motorcycles, through the state streets of Farmington. Decorate your autos with banners and flags. Live in the motto, land of the free, home of the brave. That's sovereign citizen. Let's pick a random month for posts. Let's look at April 2018. Just randomly. Let's see. Yeah, nothing fun there. September 2015. City attorney, city manager runs Cedar Hills, not the mayor. That is true on many cases. Invitation to all candidates for the Cedar Hills Council. Yeah, well, I'm bored of these guys. So, with that, stay tuned. Like I said, I thought we were done. The next step, I think, is going to be removal to federal district court for the District of Utah, and then 12B6. Second verse, same as the first. It's going to look exactly like the procedure for his case against the president and Congress. So, with that, thank you for joining me. Like I said, hopefully I will get the BitBoy crypto and other finance influencers case discussed sometime this weekend. But for now, I think my brain needs rest. So, thanks for joining me. I'll see you guys soon. Like, share, subscribe, do all the fun YouTubey things on your way out. Bye-bye.